Thank you, Mr. Speaker. Mr. Speaker, I yield myself such time as I may consume.
Recognized.
Mr. Speaker, I rise today in opposition to this extension of the 3 expiring provisions of the USA PATRIOT Act and the Intelligence Reform of Terrorism Prevention Act. When we last considered these expiring provisions, it was to extend them temporarily so that the House could review them and consider whether to improve them or allow them to expire. Many members on both sides of the aisle objected to extending these provisions without so much as a hearing or an opportunity to debate changes to the law. In fact, the extension was rejected the first time with the votes of both Democrats and Republicans. Since that debate, Chairman Sensenbrenner did in fact hold a series of hearings in which members of the Judiciary Committee were able to consider the issues and hear from many thoughtful experts who were able to make helpful suggestions. These 3 provisions dealing with roving wiretap authority, expansion of the definition of an agent of a foreign power to include so-called lone wolves, and Section 215, which allows the government to obtain business and library records using an order from the Foreign Intelligence Surveillance Court instead of the normal methods, have aroused a great deal of controversy and concern, and rightly so. Section 215 authorizes the government to obtain, quote, any tangible thing, unquote, relevant to a terrorism investigation, even if there is no showing that the thing pertains to suspected terrorists or terrorist activities. Section 215 is sweeping in its scope, and the government is not required to show reasonable suspicion or probable cause before undertaking an investigation that infringes upon a person's privacy. Congress should either ensure that things collected with this power have a meaningful nexus to suspected terrorist activity, or should allow this provision to expire. Section 206 provides for roving wiretaps, which permit the government to obtain intelligence surveillance orders that identify neither the person to be tapped nor the facility to be tapped. There's virtually no particularity required. This seems a clear violation of the Fourth Amendment. There are almost no limits on this authority and no requirement that the government name a specific target, either a person or a location. Section 6001 of the Intelligence Reform and Terrorism Prevention Act of 2004, the so-called lone wolf provision, permits secret intelligence surveillance of non-U.S. persons who are not affiliated with a foreign government or organization. According to government testimony, this provision has never been used, yet we are told it is vital that it remain on the books. Surveillance of an individual who conceitedly is not working with a foreign government or with a terrorist organization is not normally what we understand as foreign intelligence. There may be many good reasons for government to keep tabs on such an individual, but there is no reason to suspend all our normal laws under the pretext that this is a foreign intelligence operation. We are now told we must simply punt for a few years. No need, we have been told, to consider any of the many improvements that many members believe are important. No need, in fact, even to have a debate or a vote on those changes. It's another my way or the highway vote. That is no way to protect our nation from terrorism while protecting our fundamental liberties from government intrusion. I realize that the Republican majority has the votes to extend these expiring authorities, but I am proud to stand with my colleagues of both parties in opposition to the flippant and reckless way in which our liberties are being treated today. I urge my colleagues to reject this dangerous legislation and demand that the House have a serious debate on the important issues impacted by this legislation affecting our security and our liberty.